All right, welcome everyone. If you're here to learn about the law, you're in the right place. If you don't want to learn about the law, you can leave now, it's not too late. My name is Jim, and this is Legal Issues about Internet-Connected Device Scanning. All right, this is the boring slide. So my bio very briefly, if you care. I am an attorney. I've been an attorney for 5 years. I spent 3 years doing criminal law as a public defender. And then after that, I've moved on to doing internet privacy law in San Francisco with trustee for the past 2 years. And before law school, which is a long time ago now, I was a developer, but that was a long time ago, so don't ask me to develop anything anymore. But I'm here today to talk about the law and just to educate you on the basics. Now, of course, I'm an attorney, so that means there's a disclaimer. I have to say, even though I'm talking about the law, please don't use this as legal advice. I'm no substitute for specific information on your own personal situation. Don't go into court and say, I heard this guy at GrrCON and he told me this. That will go badly. So, this is only an hour long and only covers the basics. Law is always about one person's particular situation. Every little fact can make a difference. So you can't substitute this for real legal advice, but I hope it gives you the basics in understanding the law. All right, first, what do I mean when I say internet-connected device scanning? What am I talking about? You probably know what I mean, but just so we're on the same page. I mean, if you're doing research about anything connected to the internet, whether it's a computer or a phone or a home appliance that's internet connected, whatever, something's out there on the internet and you want to learn more about that device. And there's a couple ways you might go about that. You might try to log into the machine or access it directly. That's one way of quote unquote scanning a device or learning more about it. Or you might look at the traffic that's going to or from the device. Both of those situations I'm going to cover today. There's laws about both of those, and that's what I mean by internet-connected device scanning. So why am I giving this talk? Why did I decide to fly out here and give a talk? About a year ago, a friend of mine named Brandon, or C-Stone, some of you might know him, he was doing some personal research. He works for a security research company, but he had a side project. And he came to me and he asked me, what I want to do is I want to scan all across the internet for certain small home office devices. They're internet connected. They have what are now known as forever day exploits. Basically, the vendors for these small devices, the vendors themselves are quite small. They're not the biggies like Cisco. They know their exploits available for these devices, and they've straight out said, we're never going to patch these exploits. They're just going to be vulnerable forever because we can't be bothered to patch them, or it's just not profitable for us to patch them. We're not going to do it. So he was wondering, well, how many of those devices are actually out there? Like, what's the number of people who are vulnerable? What kind of places are these devices in? They're supposed to be in homes or offices, but are they in larger industrial areas, in larger companies? What's the scope of this problem? So he came to me and asked me, well, is there any problem with that? Can I just scan for these devices? Are there any legal issues? Am I safe? Could I get in trouble for doing this? And so, I gave him the basics that I'm going to give all of you about the law so that he could make a smart decision about what kind of research he was going to do and what he was going to tell the world about his research as well. It's one thing to know what the law is, it's another thing to break the law, and it's a third thing to then run around and tell everyone that you've broken the law. So that's why I'm giving this talk. I also gave this talk at ThoughtCon back in April, and I was earlier on in the day, and I went back to the speaker area, and another guy came up to me and he's like, oh, I'm a speaker too, and we introduced each other. And he said, hey, I saw your talk. He's like, I'm giving a talk in a couple hours, and based on your talk, I changed one of my slides in my talk because I said some things maybe I shouldn't have. And he said, thanks for giving your talk. So I said, great, I'm glad I made a difference. Hopefully, if there's one person out there who learn something that they can use to protect themselves today, I've done my job here. That's all I'm trying to do. Why am I not giving this talk? I'm not giving this talk in order to scare anybody. I'm not giving this talk to make anyone think, oh my God, I'm going to be arrested. The feds are going to come for me because of what I've done or something I'm planning on doing. I'm not trying to scare anybody. I'm not trying to say that you shouldn't do anything, that you shouldn't research or you shouldn't, poke around the internet, that you shouldn't be curious. I'm just giving you information so that you can make smart choices when you do research or look around on the internet. So do not be worried about anything. Bottom line is you should just be aware of the law. And I think in our community, in the hacker community, there needs to be more awareness about what the law says so that we can make smart choices. No one wants to end up in prison. No one wants to be in the press with people, get arrested, have your name out there as someone who's been arrested for violating computer crime laws. In some cases, it can end up being good press, but in other cases, it can end up badly. So we just all need to be aware of the law. So I'm covering two aspects today, both civil and criminal law. I'm going to spend most of the time on criminal law for a couple of reasons. One, it's a little more exciting, but two, it's more definite. In criminal law, you have to lay out, definite codes of conduct. Civil law is much more nebulous, and it's harder for me to give advice about civil law without, again, giving you real legal advice and knowing your particular situation. So we are going to cover both. Civil law is going to be more like general tips on what to do, what not to do, but we're going to talk in depth about a couple different criminal laws out there. All right. The main criminal law we're talking about today is the Computer Fraud and Abuse Act, or CFAA. This is the main federal law that covers computer crimes. And it's been with us for a long time now. Congress actually passed this for the first time back in the early 80s and has amended it 5 or 6 times since then and will continue to amend it as we move forward. It was passed quite early. So, before the internet was even really a thing, this law existed. It was quite proactive at the time when Congress passed it. Having said that, this is Congress we're talking about. So as you'll see, it's not perfect. Congress doesn't get computers. Congress doesn't really get the internet, as we all know. They continue to try to pass ridiculous laws like SOPA and PIPA and other things. Having said that, at the time when they passed this, they really were forward-thinking. So when Congress passed the law, they're trying to prevent people from accessing computers in certain ways. Here's the main text of the Computer Fraud and Abuse Act in its basic form when they first passed it. And if you're following along at home, it's 18 U.S. 1030. You can look it up later. All right, there's a lot of language here. I'm going to unpack it. But the law says it is a crime to intentionally access a protected computer without authorization or exceeding authorized access and doing one of the following items. So first of all, the first thing you need to know is that this is intentional. You cannot accidentally become a criminal through this law. If you accidentally access a computer you weren't supposed to, it's fine. You can breathe easy. This is only about intentionally. This is you going out on purpose to access a computer. And you have to do one of the following special things. This is the heart of the law. You have to not only access the computer without authorization, but you have to have intent to defraud or extort someone. You have to be trying to get passwords so that you can traffic in those passwords, stolen passwords. You have to try to obtain US government secrets or data, or you have to be trying to cause physical injury or threat to the public. So I think we can agree these are all, for the most part, bad things. We don't want people running around trying to commit fraud. We don't want people stealing our password files and then selling access to our email account or something. And government secrets, maybe we can debate about whether that's such a bad deal, but in general, there might be some secrets we want the government to keep, and we don't want anyone causing physical injury. That's obvious. Now, what's a protected computer? The law says US government computers, And again, you can debate about, well, are all government computers really deserving of special protection? You know, do we really care if the NASA web server goes down as much as we care about, you know, air traffic control computers? Maybe not, but they decide to protect all US government computers. All right, it's reasonable. And they protect computers, our financial institution computers. We don't want people hacking our bank accounts and stealing our money. Okay, so far all of this is pretty reasonable. Congress did a good job. Except this isn't the whole law. Remember, this is the US Congress we're talking about. They couldn't stop here and just say, hey, that's not a bad law. Look, we're protecting people from computer crime. No, 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 no. This is Congress. They screwed it up. And this is how they screwed it up. They added 2 more things. First of all, they said that on the list of bad things that you have to do to violate the law, they added this cute line: obtain any information from any protected computer. Awesome. So instead of committing fraud or stealing passwords, it's any information, anything, like the version of the operating system. That's information. It is. So now they broadened it to cover anything that you could possibly learn from a computer. Great. Well, at least it's only from protected computers, right? So it's only US government computers or financial institutions? Nope. It's any computer that communicates over state lines. In other words, any computer connected to the internet. Awesome. Thanks, Congress. Good job. So we go from like a narrowly scoped law that actually protects us against bad things to one that now covers basically anything in the world and any computer in the world. So what are we left with to argue about? Like, if obtaining any information from any computer is a crime, then me checking my email is a crime. This doesn't make sense. Well, we're left with these highlighted phrases here: without authorization or exceeding authorized access. You know, they broadened it so much that now those 2 phrases are the only ones we really care about. You know, you might ask, actually, well, if it's obtaining any information, why do we also have the list of other prohibited activities? The answer is the punishments are greater if you do one of the other listed things. But now they've kept it quite broad. So when you think about this, you have to think about, you can basically ignore the prohibited activities unless you're actually doing one of those, in which case maybe you should be a little scared. But if you're just scanning internet devices, you really need to worry about doing it without authorization or exceeding authorized access. And really, those are 2 versions of the same idea. Unauthorized access means access to that machine or service, and exceeding access means, you know, it seems straightforward, but you have the right to be on a certain machine or use a certain service, but you use some sort of exploit or attack to escalate your privileges and gain access to information you weren't supposed to have. And these concepts are important because not only are they the basis for the CFAA, but remember I said this was passed back in the early 80s, back before any of the states were really doing anything in this area. So pretty much every state has used these same concepts to create their own state laws as well. So in learning about the federal law today, you'll also learn about state law, and we'll go into a little bit of state law later. But you know, because the CFAA was at the forefront of computer crimes law, it's also really important to know these concepts for state law as well. And I put some other laws there. I have Nevada up there because that's actually where I'm licensed as an attorney. And Massachusetts actually has a very interesting law where they go into more detail than most states do on their computer laws. And they say if there's some service or a computer where there's a password prompt, where you are prompted for a password and you somehow evade putting in a password, that is unauthorized access under the law. So they're very specific. Like, they're not saying other kinds of access can't be unauthorized, but they're saying specifically, if you somehow evade entering a password when you're supposed to, yeah, that's unauthorized access. And I think that's a pretty fair statement. Even if other states or the federal law don't spell that out, if you are somehow managing to get access to something without putting in a password when you were supposed to, you might want to think about maybe not doing that, or at least not telling a bunch of people that you did that. And then at that URL I have at the bottom, that's a list of all the state's laws. I'm going to put up Michigan's later, but if you're from a different state, that's a good place to check out. And finally, we have the scary part. It is a felony. You could spend from 1 to 20 years in federal prison, depending on how much they don't like you. You could get fined a bunch of money, and it'll basically be bad. So, but I'm trying not to scare people today. Okay, so telling you what the law is fine. We can all read the law. Maybe you will understand the law. Maybe you feel like you don't understand the law. What we're going to do is we're going to go through a series of hypothetical questions or scenarios that are somewhat real life that'll hopefully help you understand what the law really means, you know, where the rubber hits the road here. This is kind of the same method they use in law school, which, by the way, you know, lucky you didn't have to go. I went so you didn't have to. Yeah. But this is the same method. We do a lot of hypothetical situations, you know, cute little stories to try to figure out the law and understand what it really means in real life. All right. Example 1. Alice notices that her neighbor Bob is using a NinjaTel router. Alice does a quick search and finds the default password for the router is password and decides to check if Bob bothered to change the default or not. And if he hasn't, then she plans to warn him about, hey, you really need to change your default password because, you know, evil bad hackers could come and own your network. So she does, and you know, she tests and finds that Bob has, in fact, the default password. She's able to get into the network. But instead of warning Bob, she forgets about it. She goes and gets lunch instead, never tells Bob anything, and the default password's left. Is this a problem? Yes. It is a problem. Alice is not authorized to use Bob's network. There is a password in place to access this router. Now, some people say, well, wait a minute, but it's the default password. Alice actually knows what the password is. She didn't use any shenanigans to get the password. There's no, you know, attacks using some kind of code, or there's no brute force going on. She actually knows what the password is. Doesn't that mean she's authorized? No. She is not authorized. Bob did not say to Alice, yes, you can log into my network. She has no business using this network, even though it's a default password. So, I mean, look, if you get caught for this and your only defense is, well, it's the default password, so I felt like I had permission, fine, roll with that. But realistically, I wouldn't. That's not a great defense. Don't leave yourself that defense. Now, I've also asked a couple other questions. What if she actually remembers to warn Bob? That doesn't really make a difference. The CFAA doesn't care if you're a good person. They don't care if you're doing academic research. The statute doesn't care if you're a white hat, not a black hat. It doesn't have exceptions for any of this. It's very black and white. If you do this thing, it's a crime. Now, realistically, you know, if Alice goes and tells Bob this, are the feds going to knock down Alice's door and arrest her? No, of course not. That's silly. But as far as the law is concerned, her intentions don't matter. Her motive doesn't matter. What matters is that she intentionally accessed the router without authorization and accessed the network. Now, what if Alice does something worse and she logs in the network and then screws around with it and breaks Bob's network, or owns his computers, whatever? Well, yes, that makes it worse. It's probably, but again, it doesn't make any difference as far as actually violating the law. It'll make a difference as far as how Alice is punished under the law, but not in whether or not the law is violated. What was that? Is Bob sharing the management interface? Now the question is, if Bob is sharing the management interface online, isn't he basically inviting other people in? I think the analogy goes to, if you leave the door to your house open, are you inviting people to come take your stuff? And the answer is no. Is Bob stupid? Maybe. But again, the law doesn't care if the victim is stupid. The law cares about what Alice is doing. So no, it does not make a difference if Bob should have taken better security precautions, maybe. It only matters what Alice is doing in this case. Example number 2. At Alice's job, she has access to her company's payroll system, but only for the purpose of ordering reimbursement checks for other employees, not for any other purpose. However, her boss goes to lunch and she decides to wander over to her boss's computer, and her boss has administrator rights, and she checks out all her coworkers' salaries, and of course tells all her coworkers what their different salaries are and who's making what, and starts a bunch of drama at work. Now, for one, she's going to get fired. But 2, is she in legal trouble too? Well, yeah, possibly. And this goes back to the not unauthorized access, because Alice has permission to be on the payroll system. She has her own access to that. She has her own login. But in this case, she does not have the right to be an administrator. She's exceeding her authorized access. She's looking at things she's not supposed to look at. So in this case, she could be in legal trouble as well. It's hard to come up with examples for unauthorized access that aren't really obvious. Yeah. All right, so the question is, basically, if you're logging into a system and there's either a banner message or maybe even in the terms of service somewhere, it says, by using, as part of using this system, you agree not to do X on the system. You agree not to access this at home or something like that. Does that do any good legally? I think it does good as far as cutting off your access. Like if the company or service says, okay, you violated the terms of service of the banner message, we're cutting off your access, goodbye. I think that does good for them. But what we don't want to get into is making violation of terms of service a crime, which if you remember the case, I forget her name, Lori Drew from Facebook, they were trying to make the argument that by violating Facebook terms of service, she was violating the CFAA because she was exceeding her access because she was doing something against the terms of service. That's a whole big can of worms, and the EFF is fighting that fight to make sure that does not happen. We don't want, if I share my friend's stuff on Facebook in a way they don't like, I don't want that to be a federal crime. That makes no sense at all. I don't think that's going to happen. The courts don't want everybody coming into getting arrested for violating terms of service. Unauthorized access under CFAA, really means like cases like this where there's a clear delineation. You're not supposed to look at something and you go and do it anyway. Again, it has to be intentional under the CFAA as well. You can't, if you accidentally, if a programmer screws up in designing the interface and you accidentally stumble onto administrator privileges, that's not a crime. You have to be intending to go access parts of the system that you're not supposed to be accessing. So the question is, okay, so in this case, the company, say, calls the police and says, Alice did this thing. Who decides whether she gets prosecuted? And the answer is the district attorney or we call the assistant U.S. attorney. The government prosecutors decide. The company doesn't really have a say in whether someone gets prosecuted for a crime. Under civil liability, the company can always sue Alice. They can complain and make noise to a prosecutor, but it's the prosecutor's job to decide who gets charged with what. And I think, especially in the federal system, federal prosecutors, they're not interested in small-time stuff like this. They'd be like, yeah, whatever. She got fired. What do you want us to do? Unless she really went, if she took it really far, yeah, they're going to come after her. But is the company obligated to report this? I'm going to give you a lawyer answer. It depends, because states have what are called data breach notification requirements, which basically says that if your customer's data gets stolen or it could have been stolen, you may have an obligation to report, but there's no federal data breach notification requirement. It's different in every state. And so I don't want to say yes or no because it really does depend on the situation and on the state you're in. Here's Michigan's law, really quick. And again, if you want to follow at home, it's 752.795. And I'm not going to read it in too much detail, but you can just see it basically tracks the CFAA. And this is common for all states. They pretty much copy the CFAA language directly about unauthorized access or exceeding access. Although I will note that Michigan's punishments are actually pretty harsh from most states that I've seen. Up to 5 years, or 10 years if you do it more than once. Although if you get caught and go to prison and then come out and do it again, you know. So here's another example, and it brings up some new issues. So now Alice wants revenge against Chris for being fired. She's pissed off. So from her home in Michigan, Alice legally accesses a server located in New York, which has some personal data of Chris's, and steals it in order to blackmail Chris. Chris lives in California. Now, I'm not asking if Alice did something bad, because yeah, she totally did. I mean, you know, you can't hack into a computer and steal stuff and try to blackmail someone and think it's not a crime. That's a crime. But where is she in trouble is the question. What states and or what part of the government is going to be mad at her? I hear 2 New Yorks and 2 federals. All right, the answer is definitely New York will be mad because that's where the data was sitting. Michigan might be mad because that's where Alice is. In California, probably not, because there's no data or server or anything that was accessed in California. Even though Chris is the victim of this case, not going to be in trouble there. And also federal as well, because we're crossing state lines in order to access the data. So that brings up the federal law. So I say Michigan maybe. Realistically, New York is probably going to be the one who's most upset about the situation because that's where the server, that's where the data is sitting. Now, Alice can get in trouble both in New York and under the federal system. That is not double jeopardy. And it has to do with a fun legal doctrine known as the two sovereigns doctrine, which basically says that it is not double jeopardy if a different state or jurisdiction charges you for the same crime. It's only double jeopardy if, say, like, she gets charged once in Michigan, goes to jail. While she's in jail, they charge her again for the same act. That's double jeopardy. You can't do that. But you can get in trouble both in the state and under federal law for the exact same act. The way it works in real life usually is that unless they really don't like you for some reason, they'll pick one. Like either the state will come get you or the feds will come get you. And then even if both come get you, there's questions about how you'll be punished, etc. But you can get punished by more than one jurisdiction. All right. So that was the CFAA. That's when you access the machine directly or exceed your authorized access. Now I want to talk about wiretapping. And you know, when you hear the term wiretapping, you kind of get this romantic notion of someone up on like the telephone pole with the lineman's handset listening in on calls. And originally that's exactly what this law was intended to prevent. This was passed back in the 60s. But it has grown to cover a lot of online activity as well. Now, basically, it's illegal to intercept any communication in transit without permission. How much permission you need varies. Under the federal law and in most states, you only need one party permission. One party to the communication has to have given you permission for you to intercept the communication and not get in trouble. In a few states, you have to have all parties' permission. All parties to the communication must give you permission for you to be able to intercept. And those all-party states, some of the biggies are California, Washington, Nevada, and Michigan. Michigan is an all-party state. You have to have permission from everybody who's a party to the communication before you can intercept. His question is that the same thing as recording the conversation? Yes, in that I guess if you intercepted it but never did anything with it, then no one would know. Okay, the question is, if you're in Michigan and you record your own phone conversation and don't tell the other person, is that possibly violating the law? I think the answer is probably yes, there is that possibility because this is an all-party state. You're supposed to get permission from everybody. Because there's not a big distinction between where you intercept. Like, you're intercepting at an endpoint, but that's still wiretapping. Yes? The question is it permission or notification? It's supposed to be permission, but as we all know, if you've ever called a call center, they'll play that little message that said, this call might be recorded to better serve you, blah, 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 blah. It's implied permission because they're basically saying if you don't want to be recorded, you can feel free to hang up now. So yeah, in real life, it's kind of notification, but the legal standard is permission. However, I think you'd have a hard time going and saying, oh, I didn't know, and they'll replay the call, and they'll be like, well, there's this audio notice that this is going to happen. There is an important exception. If you remember, the CFAA didn't have any good exceptions. There's no exceptions for being a security researcher or anything like that. But under wiretapping, there is a really handy exception. If you are the one running the network or the service, you are allowed to look at traffic in order to maintain the service itself and the security around that service. So this should come into play for a lot of you when it comes to work and monitoring your own networks. You know, as long as you're using it for a legitimate purpose. Let's go through some examples. Because again, this is all very vague. Let's go through some examples. All right, since now Alice is out of a job, she got fired from the last one, she decides to learn more about the internet, installs Wireshark on her computer. And at home, she activates the program and records an instant message conversation between herself and her friend Dave. She does not ask Dave's permission. This goes back to your question about telephone. Is Alice in trouble? It depends. In a one-party state, she's not in trouble. Although she's not asked anyone permission, she has permission from herself to record her own conversation, we would imagine, unless there's some, movie-style split personality shenanigans going on here. She gave herself permission to record, so in a one-party state, this is fine. She can record her own conversation without a problem. But in an all-party state, like Michigan, there might be a problem here, because she does not have all parties' permission to record everything or examine the conversation. Yes? If you Yes. All right, so what if you're in a Facebook chat and you just copy-paste the chat? I think you have and this does get back to some semantics when I talked about recording at the endpoint. I think you actually probably could do that because wiretapping is only during transmission. And I don't want to get into it too much, but there's a whole quagmire in federal law about whether something's in transmission or whether it's at rest. It makes a big difference for a lot of different laws, computer crimes laws. And it's one of those things where I went to like a legal conference about that, and we basically talked about that issue for like 8 hours, and the answer was, who knows? Or the answer was, it's really complicated, and it takes like specialist lawyers. So I don't want to get into that, but no, once the transmission is done, then there's no more wiretapping. I think for phone, they kind of say it's transmitting for mostly the whole way, but for Facebook chat, no. If you copy paste it out of the window, I don't think that would be considered wiretapping. But I'm not legal advice. Indeed. Most IM clients will offer the opportunity to archive conversations. Again, just because this may technically be illegal doesn't mean the feds are going to be like, haha. You copy-pasted a Facebook chat. You're going down. Yeah. All right, example number 2. Alice loves this whole packet capturing thing. This is great. I can listen to all sorts of people's conversation. Alice decides to go to her local coffee shop and see what's being sent over the unsecured Wi-Fi at the coffee shop. Not that anyone in this room has ever done that. In the process, she again records her conversation with friend Dave, but she also intercepts someone else's IM conversation between Ellen and Frank. Again, she of course doesn't ask anyone's permission to do this. Is she in trouble? Well, it seems kind of obvious. We already went over the one with Dave, so maybe, maybe not. It seems pretty obvious that the conversation between Ellen and Frank, she doesn't know these people. She's just reading what they're writing each other over the internet. It seems like, duh, it's wiretapping. What else do you need? But there was a court case just last month, and unfortunately the URL gives away the punchline, but whatever. There's a court case just last month, in Illinois no less, where the judge said, because it was an open Wi-Fi network, because it wasn't secured, there is no wiretapping here. If it's an open Wi-Fi network, it means it's the same thing as going out in the middle of the street and just shouting your conversation. Everyone thinks that was a stupid decision. And it also goes against, there's a court case out of the Ninth Circuit, which is the California area, where the court held the opposite. And they said, no, even if it's unsecured Wi-Fi, that doesn't give you a license to just go recording everything on it. So both cases are being appealed. So I don't have a great answer. I don't think it's open season in Illinois. Like I wouldn't run over there and start recording everyone's Wi-Fi and like reading everyone's. I would not recommend that. Or if you do that, don't tell everybody you're doing that. But so the law is still in a state of flux, which is a little silly now. Like how long have we had computers now? How long has the internet existed? And the law is still like, we don't know. And it gets, so it puts me in a weird place. I'm up here trying to guide you. At the same time, the courts do silly things like say, yeah, listen in on Wi-Fi networks, whatever. But that's, I think it's clear, okay, in an all-party state, clearly, I don't think she's doing a good job here. I would not recommend running around coffee shops and listening to people's conversations. But that's what the court said. You had a question in the yellow shirt before. Yes. So how do terms of service type things affect legality in respect to wiretapping? I think they have a greater effect for wiretapping because it goes back to we have this long tradition of when you call the call center, they tell you, hey, we're going to record your conversation. They don't really wait for you to respond if that's okay or not. So it may work better for wiretapping. And remember, whoever's running the service has a certain degree, has some latitude in listening in on conversations to protect their own network as well. Yes. All right, so the question, going back to CFAA for a second. So if Alice is trying to log into Bob's router and there was no password at all, it's just open, is that okay? I would still say it's probably not okay because, again, she doesn't have permission to access the router. She didn't ask Bob, hey, can I access your router? Will it be harder for them to show that there was no permission? Maybe. There's definitely more arguments to make when there's no password protection at all. It's just an open service to the world. Yeah, you have pretty good defenses. And are the feds going to really want to take you down for that? Spend the time and effort? Maybe not. But that does depend a lot on the particular situation as well. If it's a service that's being presented to the public on purpose versus is it a service that, accidentally got left open, something like that. Yes. Yes. So if you're monitoring things in order because you have obligations under HIPAA to monitor certain things, I mean, If the federal law and your lawyer says you're supposed to do it, then you should do it. Yeah, monitoring to meet your requirements for federal law under HIPAA or something like that would probably be fine. I'm not a HIPAA expert, so I can't really speak to what HIPAA says you should and shouldn't do. Okay. The question is, what if you have a phone call, if you're an all-party state and you have a phone call with the police, are you allowed to monitor them because they're the police? I don't think that really changes the equation in an all-party state. Monitoring them when they're out in public is a different set of laws than this. This only, wiretapping is only about communication, electronic or analog communication. I have two more examples, so let me get through those and then we'll have time for more questions at the end, don't worry. All right, example 3. After exposing the dangers of having an open Wi-Fi network to the coffee shop, they decide to hire Alice as their network security administrator. As part of her security diligence, she will occasionally capture traffic to look for suspicious activity. She spots one patron, Gigi, using up almost all the bandwidth because Gigi's sharing torrents at the coffee shop, and proceeds to kick Gigi off the network. She also again records Ellen and Frank having an IM conversation, and she decides to read it because, hey, you never know, they might be doing something illegal. Maybe they're planning a drug deal over IM. Who knows? So she decides to read it. She doesn't ask anyone permission. Is she in trouble? Is she in Illinois or California? I'll say California. Is she in trouble? Now, for the stuff with Gigi, for figuring out what she's doing on the network, no trouble. Remember, there's an exception for wiretapping. You're allowed to look at what's going on to protect your network's security and also to provide the service and maintain the integrity of the service. So if someone's DOSing your network, yeah, you get to read their info and figure out what's going on so that you can stop them from doing that. So that's not a problem. The stuff with Ellen and Frank, maybe not. That goes back to the previous example. Yeah, she's an employee. Yeah, she's protecting the network, but that doesn't mean you get to assume everyone's a criminal and just read their conversations because who knows, it might be something bad. I mean, you're not a police officer. I'm not going to get into, you don't have to have like some reasonable doubt or, suspicion, but, this is just the point that the exception for network operators doesn't give you carte blanche to read everything that comes across your network just for fun. But you're free to read it as much as you need to maintain the service and the security. Finally, Alice decides she's had enough of Michigan, moves to Oregon, which is a one-party state. She dials into a conference line phone conference line in order to speak with 3 other people who are all in California, which is an all-party state. I put 2-party, but it's an all-party state. So prior to the call, she gets one person's permission to record the call, but not the other 2. And she records the conversation. She wiretaps the conversation. Is she in trouble? Because now she's located in a one-party state, but everybody else is in an all-party state, and she didn't ask everybody else's permission. The answer is she's probably not in trouble. Wiretapping cares, because there are state statutes, even the federal statute, it cares where, the federal statute says you need one-party permission, which she got. So the federal statute says you're fine. The state statutes care about where the wiretapping takes place. If she's tapping it in Oregon, she needs one party's permission. If she sneaks over to California and decides to tap it there, then she needs everyone's permission. So it makes a difference what state you're in. You need to know when you're in the all-party states because it really does make a big difference about the extent of wiretapping you're allowed to do. I've told people this. I'm like, if you want to be really on like the white hat side, if you want to be a good person, do your security research from a one-party state because you get a lot more. You get to do a lot more when it comes to intercepting communications. Oh yeah, a moment of realism. Although I've been doing this throughout the talk, so it's okay. Are the feds going to bust down your door for recording an IM conversation? Probably not. Again, I'm not trying to scare people here. We just went through some scary criminal stuff, and I said, this is illegal, don't do this, don't do that. Again, if you don't run around telling people, and if you're not doing things that are really bad, how much will the feds care? I can't say. But, I just want to, everyone pause, take a deep breath. If you're scared the feds are going to come get you, probably not. All right, so briefly on civil, and it will be brief. Civil lawsuits are what happens when you piss someone off. They'll sue you. And they can kind of sue you for any stupid reason. Now, there's some truth to this because you can be sued. Whenever you hear a news report, oh, this person got sued. I mean, that doesn't mean anything. You can sue someone for anything. Whether there's merit to that is what matters. But even if there's no merit to it, even if it's completely stupid, especially when it comes to computer stuff, judges will be like, ugh, I don't understand this crazy internet that you're talking about. Who knows what's going on here? It could take a lot of time and a lot of money, even if it's a really stupid lawsuit. And you're going to have to get a lawyer, you have to call the EFF, it's going to be a pain in your ass. Ugh. You don't want to deal with it. Even if it's a baseless lawsuit, you really don't want to deal with it. So basically, my advice for civil lawsuits, don't break stuff. Most people will only sue you civilly if you cost them money. Most people they're not going to spend thousands of dollars suing you if you didn't break anything and you kind of just hurt their pride. Some people will, don't get me wrong. Most businesses, most people out there will not. So as far as civil goes, don't break stuff, please, and you probably won't get sued. Although it still might be a crime because so, as far as civil goes, it's really, there's too many civil laws out there that people can sue you under, and it really depends on your situation. So I can only give you the general advice of don't break things, and you'll probably be okay. So some general tips then for civil, but this also applies to criminal. Ask permission when you can. If you're going to run around scanning things on the internet and you're in a gray area, see if you can ask permission. I mean, sometimes that's not reasonable. Like my friend I mentioned at the beginning, Brandon, he wanted to scan across the whole internet to see who had these internet devices. He can't go to every homeowner and be like, knock on their door. Be like, hey, can I scan your router? It's ridiculous. So, but when you can, ask permission. Don't break stuff. And, follow the golden rule. Would you be okay with someone else sitting in this room doing the exact same thing to your hardware or network? If the answer is no, well, why are you going to do it? I don't know. Follow the golden rule. If you know you're in a gray area or you think you might be, don't run around talking about it. And you can get legal advice. You can ask a lawyer or ask the EFF. There's plenty of free legal advice. I know people are intimidated. They think lawyers cost a lot of money. They don't know a lot of lawyers. They don't want to take up too much time. Don't worry about that. We're here to help. I'm here to help. EFF's here to help. CET's here to help. Whoever. Lawyers are happy to help you if you just have a question. You can call us up. It's fine. And anything you say, even if we don't end up taking your case, even if we don't end up charging you money, it can be protected under attorney-client privilege, even initial discussions. So don't be scared about talking to attorneys. All right, I think I have about 10 more minutes, and I have time for more questions. I know people had more questions. Yes. Yes. So you're at home and you have your own Wi-Fi network, which most of us do. Can you monitor your own personal Wi-Fi network at home? Answer is yes. Yes, you can. You are running your own home network. Again, I wouldn't go crazy and dump out everyone's conversations. But at least you have a defense. If you do that, let's say you did that. Let's say you have your home network and you're copying every single thing that goes across your network and reading all of it. At least you have a defense with wiretapping. You have that exception. You're like, I'm running the network. I'm just seeing what's going on. You have a pretty decent defense there. Now, whether or not it works is another question. But I wouldn't, if you're running the network, I wouldn't worry as much about wiretapping. you're probably okay. Again, if you then take that information and use it to do something with it, like you record people's passwords to their email and then log into their email, like that's bad. But like, if you're just recording traffic on your own network, again, realistically, you're probably okay. The gentleman back there. Back here. Oh, okay. All right, so you happen to be wiretapping. I'll say you're wiretapping illegally, hopefully not. But let's say you're doing some illegal wiretapping and you happen to like actually catch them in the IM conversation planning the drug deal. What should you do? I think in that case, if you went to the police, they would, and they, it turns out, yes, they catch them and they were actually planning this big drug deal and you saved the day. Would then the police turn around and charge you with wiretapping? I mean, theoretically, yeah, they could. Would they be dicks? Yes. And then the problem, but then if they did that, then no one would ever come to them if they saw that again. So it's bad for them to do. Is it admissible evidence? Yes. Yes. It's illegally obtained evidence, but it's still admissible in court. It might be inadmissible if the police had used shenanigans to get it, but it's still admissible if you're doing something illegal in court. But yeah, again, for a lot of this stuff, again, realistically, if you're doing legitimate academic research, or if you catch someone doing a much worse crime and go to the police, if the police or FBI or whoever turn around and charge you, like they're stupids, so they might, but but that would be bad for them because then no one would ever come to them again to help them out. Like, it'd have a chilling effect on everybody. So I think it's pretty unlikely that they would do that. Now, it doesn't mean they haven't rallied their sabers before about that kind of stuff. There's been talks at GrrCON that have been canceled that were academic researchers because the police said, hey, you're doing something illegal, and so they had to cancel their talk. I don't think that they were ever charged or got punished for it, but it can happen. I don't think it's wise of the police to do that. We're trying to help them out. Or they turn around and do that. Yes. Legality of war driving. So there is a difference when it comes to war driving, I think. Some courts might disagree. Because wireless access points on purpose broadcast information, their SSID or their IDs, whether or not they're protected. That's not, you're not accessing the device. You're just capturing things that are being publicly transmitted on purpose. I don't think there's a problem with that. There can be problems when it comes to how you phrase how you publish it, I would say. If you publish the information or like, hey, there's this access point over here and we tried the default password to the admin interface and it totally works, like that's not so great. But if you're just publishing the existence of an access point and using that data, I don't think there's much of a problem there. Again, some courts might disagree. And who knows, some states might have wacky war driving laws. Always make sure your own state's laws are okay, they don't prohibit anything. Yes. That's a good question. Okay, so the question is, example 2, Alice gets fired from her job, but her company is stupid and forgets to change her password or remove her account from their payroll system, and then she again accesses the payroll system using her account. Is that unauthorized access? That's a really good question. That would be a good case. Because you can see both sides of that argument. She still has a valid login and password, but at the same time, she's been actively told by her company probably when she got fired, like you can't access that system anymore, like, or it's kind of understood when you're fired. You're really not supposed to access that system anymore. That's the kind of thing where she would probably definitely be charged by the police. Where it went from there would rely a lot more on that particular state's laws and any other dirt they can find on her. So it's kind of, but that's like a really gray area question. I don't think it's a good idea if you get fired or no longer work for a certain employer to use your old logins. It's probably not the greatest. If you like to stay out of gray areas, that's probably not a good one to do. And the blue. I'm sorry, I missed the first part. Oh, at the beginning, Brandon. Um, it's not. Well, I don't know what he did. So if you're okay, so if you're scanning the internet for many devices, I would say no. If you're scanning for the mere existence of a device, you yeah, like something exists at this IP address. That's obviously fine. The problem is, I think, when it came down to figuring out whether it ran the particular version of firmware that is exploitable, like how do you find that out? Some services will just tell you their version when you talk to them. That would be okay. But some you have to poke them and prod them in special ways. I mean, there's scans you do where it's like, well, if I send you this malformed packet, then you'll send me back this. That means you're this version. I mean, that stuff I think is in a gray area because you are actually, at that point, when you start interacting with the device, it can be a gray area. Although I would say if it's publicly available on the internet, I would argue that's fair to do. But when it comes to trying to like brute force a password or something like that, or trying default passwords, that's where I would, if it was me, if it was my client, I would say don't do that. Like don't try default passwords. I know you want to, but don't do it. Yes. So the question is, it looks like there's researchers who may have been violating the law, and the answer is, at some point, some researchers just say, fuck it, like honestly. Like, yeah, they know what the law is, but they're just like, we gotta do what we gotta do. We need to do this research. It's important research. And hey, that's their choice. Like I'm just trying to give people, like I said, I'm just trying to let you guys know what the law is, and you can make your choices. And when it comes to, I can't say if they talked perhaps to the EFF before, they got legal counsel before, maybe they did, maybe they didn't. But yeah, a lot of the research that's presented that deals with intercepting communications, I think a fair amount of people just say, fuck it. Like, what are the chances the feds are going to come down on me? Not that great. And, yeah, I'm glad they do it because research needs to be done and you can't always ask permission. So, but as long as they were aware of the risks, that's what's important. So I believe I'm out of time, but if you would like to ask me questions, I'll either be hanging out over there having a beer or I'll be around the con. Please come up to me. And if you want to talk in private about anything, that's fine too. So let me know. Thank you very much for coming.